The graduation address gives us now the opportunity to hear from a distinguished member of our alumni community, and we're privileged today that the address will be delivered by the Honourable Justice Richard Niall. Justice Niall is a judge of the Appeal Court of the Supreme Court of Victoria, as you know, our highest court, and sits both in criminal and civil appeals. He graduated in economics and law from Monash University and commenced in legal practice in about 1990. He joined the Victorian Bar in 1995 and developed a national practice in public law and industrial law, and regularly appeared in our appeal courts and in the High Court. Justice Niall was appointed Queen's Counsel in 2010 and thereafter appointed Solicitor General for the State of Victoria in 2015. 2 years thereafter, he was appointed to the Appellate Division of the Supreme Court. Justice Niall has appeared in a broad range of areas and matters in the High Court of Australia concerning validity of Commonwealth intervention in the Northern Territory and the decision to send asylum seekers to Malaysia. He has appeared for the United Nations High Commissioner for Refugees in cases involving the power of the Australian Government to intercept and return asylum seekers at sea. He has been recognised for his work with refugees and asylum seekers through numerous awards, including the inaugural International Commission of Jurists, the John A. Gibson Award for Distinguished Human Rights and Refugee Advocacy. Justice Niall has presided as a judge in our moot court competitions, perhaps some of you were before him, and judged the final of the National InterVarsity Gibbs Constitutional Law School moot. He is also a Senior Fellow at the University of Melbourne, teaching public law and separation of powers. He's involved with many associations as a Fellow of the Australian Academy of Law and a member of the Australian Institute of Judicial Administration. 2 years ago, he was appointed a Fellow of Monash University. I therefore have much pleasure in inviting Justice Niall to deliver the graduation address.
Deputy Chancellor, the Honourable Peter Young, Deputy Vice-Chancellor, Education and Senior Vice-President, Professor Sharon Pickering, Associate Professor Caston, members of faculty, distinguished guests, ladies and gentlemen, and especially the new graduates. It is an exciting, challenging but overdue time in Victoria for our understanding and appreciation of the culture, history and strength of First Nations peoples. We have the Yurruk Justice Commission, which is engaged in a process of listening, discovery and reconciliation. There is work on a treaty and the First Peoples Assembly. One of the things I hope that we as a community get from that process is a greater understanding of the differing First Nations peoples across Victoria, including the Wotjobaluk, Jadwa, Jadawatjali, Wagaya and Japagug peoples of the Wimmera, the Gunchimara people of the southwest, the Yorta Yorta in the north, the Bunurong and the Gunakunai. There are many others. 38 languages have been recorded in Victoria. I acknowledge the diversity of First Nations peoples and that we meet today on the traditional lands of the people of the Kulin Nations and pay my respects to their elders past and present, and I acknowledge First Nations people who may be with us today. A few years ago, when I was a junior barrister, I did a case against Ian Waller. Ian is the son of the late Louis Waller, one of the preeminent members of faculty and a Lion of Monash. Ian had just been appointed a Queen's Counsel and I congratulated him on the achievement. He smiled and said it was one of the few times that you get professional recognition of a job well done, and friends and colleagues freely express their genuine happiness for you. Today is such a day for you. The leaders of the university, members of faculty and family of friends assemble today to congratulate you and to mark this wonderful occasion. I am delighted to be able to share it with you, and it brings back many memories of my own graduation some 32 years ago. Enjoy it. Reflect on your achievement. Be proud of yourselves and of your university. To complete a degree at this great university is a significant achievement. I want to reflect on the things that you will take with you as you finish this stage of your studies. Obviously enough, you will take a piece of paper, grandly embossed with the seal of the university and under the hands of the Chancellor and Vice-Chancellor. You may choose to frame it, or if you're like me, leave it rolled up and move it from house to house over a lifetime. Nonetheless, be proud of it. You will also leave with some letters after your name. For those of you today taking a law degree, it will qualify you for entry into a professional life. That is where it led me, on a course that is challenging, exciting, and rewarding. For others, it will be a key to other endeavours in the business, the arts, government, or the not-for-profit sector. You will also take things from this university that you have learned. They may inform your daily work or may unexpectedly stay with you. You will know that a contract usually requires an offer, acceptance and consideration. Negligence involves a breach of duty of care. The difference between a legal and a beneficial interest, and the trustee owes fiduciary obligations. This knowledge is important, and some of it will be indelible. In my current role as a judge of the Court of Appeal, I hear many criminal appeals. My associate recently asked me if I had ever practiced as a lawyer in criminal law. I told her I hadn't, but I had studied criminal law at Monash. You would be surprised at how valuable that has proved. You may be told that a university subject or a university essay bears no relation to the real world. Don't believe it. It is your job to connect the two. You will also take friendships and acquaintances that you will enjoy through your life. Indeed, I met my wife at this university. All these things, the piece of paper, the letters after your name, and the knowledge you have gained are very important. But in my opinion, there is something else very significant that I invite you to reflect on today. You have learned over these years how to think, and importantly, how to learn. You have spent a special time in your life where you have been required to read, understand, reflect, and analyse, and demonstrate what you have learned. You have written countless essays, exams, and undertaken in the wonderful moot courtroom of which the university is rightly proud. These have all provided you with the opportunity to consider vast amounts of information, reflect on a topic, and express your learning. Why is this important? There has never been a time where information has been more abundant and easily accessible. It risks overwhelming us. But as the Vice-Chancellor observed at a dinner I recently attended, not all information is equal. Not all ideas are equally valid or cogent. Very few things are as simple as they sound. Truth is not democratic. It does not belong to the majority or the person with the loudest voice. And maybe in many areas of life, there is no single truth. There is nuance, sophisticated learning, ideas, and different forms of expression that illuminate. You have been given the privilege of an education that gives you the tools to understand these things. Of course, a tertiary education is not essential to understanding, but your experience at this great university surely gives you a foundation from which to continue to learn and to understand. In a fulfilled and productive life, the process of learning never stops. I continue to learn, sometimes on a very steep curve. When you come to consider areas of public controversy or policy, or when you perceive there to be a suffocating consensus, that is the time to challenge, to dig into the facts, to talk and to reflect, to use the skills of analysis that this degree has given you. The sheer amount of information can lead us to accept the most prevalent view, the consensus or the status quo. You must strive to avoid this. I want to give you a few examples, each of which have been a big part of my professional life. At the bar, I did a lot of work for refugees and asylum seekers, with Debbie Mortimer, now Justice Mortimer of the Federal Court, and David Mann of Refugee Legal. I was involved in a number of important cases in the High Court. They dealt with offshore processing, the decision to send asylum seekers to Malaysia, and the lawfulness of mandatory detention. There was a significant change when the language moved to saving lives. So when I started, the language was all about tough borders and mandatory detention. There was a significant change when the language moved to saving lives at sea. Boat pushbacks, mandatory offshore detention in Nauru and Manus Island were tough, but they saved lives. They stopped the risky boat trips from Indonesia. Somehow, mandatory long-term detention on an island in the South Pacific was for the greater good, or for the benefit of other long-suffering asylum seekers. It was utilitarian. It was the right thing to do. That may be true. But in making ourselves feel better about saving lives, perhaps we lost the sense that people were coming to avoid persecution, that they were desperate and that they have agency, that pushing back boats was more about us than them. One of our graduates today took that perilous journey as an unaccompanied 16-year-old fleeing a conflict that had taken the life of family members and forced his family to flee. He spent time on Christmas Island and in detention on the mainland. To arrive here today is a testament to strength, perseverance, and the value of the human spirit, and the support of strangers, and the importance of flight. Having seen recently what we have in Ukraine, would we be sympathetic to Poland if, wanting an orderly migration program, it closed or restricted its border? Take another area. Since becoming a judge, I have done many appeals on criminal sentences, considering whether they are either manifestly excessive or manifestly inadequate. I have heard quite a few bail applications to determine whether or not an accused person would be remanded in custody or released on bail pending their trial. How we as a society best respond to crime is an enormous challenge that we face as a community, particularly as it comes at a significant financial cost. Should we spend more on jails? Does incarceration provide community protection? Is general deterrence a realistic outcome of the sentencing process? Should we tighten or relax the ability to get bail? Does the burden of the criminal justice system fall disproportionately on some? Not for one moment do I think that these areas involve simple questions with straightforward answers. People have different views, and it is impossible to come to a single correct answer. That is my point. As a judge, I always feel that I am better able to get the right result when the parties prosecute their cases with equal ability and vigour. You will all have areas that you care about. The environment, the place of women in society, First Nations people, discrimination, racial equality, poverty, a successful economy, national security. All of these things excite our minds and passions. They are all important. In all of these areas, there is always a case for change and a competition of ideas. Sometimes the change is to return to the past, sometimes the change is for a new solution. Change must be argued for, it must be strived for, but change is always difficult. However, if we are to get the best in our society, ideas must germinate. They must be advanced and they must be challenged. Ideas are not woke, they sustain us. The great Indian philosopher and economist Amartya Sen has said, "The big thing that we know from John Stuart Mill is that democracy is government by discussion. And if you make discussion fearful, you are not going to get a democracy, no matter how you count the votes." Those words are important. If you make the discussion fearful, you cannot have a democracy. Experience shows that you can make discussion fearful in many ways, from the jackboot to an overbearing consensus. And the antidote is vigorous, respectful, and robust exchange of ideas and perspectives. I return then to what you, the graduates today, will take from this place. You take the many things that I've spoken about, perhaps even a future spouse or a life partner. But I venture to suggest you also carry an obligation to participate in society, not as a passive observer, but as an engaged and enthusiastic contributor. That contribution might start with those you are close to, which after all is where we will always have the most influence. It might extend further, and some of you will have horizons that spread far beyond Australia. I am confident that, as a cohort and as individuals, you will make a significant contribution. Your sense of relief, your interest or an anxiety about what comes next may be front of your mind. But whether you appreciate it now or not, your time at Monash will prove to be a seminal time in your lives. It will have had an impact on your thinking and the way that you learn and continue to learn. Be confident, and as I said, be proud of yourselves and of your university. Thank you.
Thank you, Justice Niall, and on behalf of the graduates and all gathered here today, thank you for that very carefully crafted and obviously challenging address, and it's what we expect in law faculty addresses, that we throw out challenges to the students who go into their life, their professional life, wherever in Australia, armed with a degree from our law faculty, but knowing that there are so many challenges ahead, within or without of the courts, wherever you choose to work. It's the learning from Monash and the challenges and how you meet the challenges that will determine the next years of your life and then your progression. So thank you very much for that address.